You may know that in the law, when you ask a lawyer, is this good or is it bad? The answer might be, it depends. It depends. What is your situation? Your situation may be such that having a will that goes through probate is absolutely the best thing for you and for your surviving spouse. Or your situation may be a revocable living trust is better. It's better to avoid a probate. Which situation is right for you? Let me give you some examples. With a revocable living trust, that is a document you create while you're alive, and you must put your assets into it. Your home has to be retitled into that trust. And by the way, Washington, our recording fees for filing documents are the highest in the nation. But that doesn't mean you won't want to put your house into your revocable living trust, because for your revocable living trust to act appropriately as it's supposed to, so that it can be implemented, your house needs to be in that trust, as does your bank account and your investment accounts and anything else that you can put into the trust that should be in the trust. What can't be in your trust? Your IRA, your 401k, obviously your pension, because that's an income stream, not an asset that you can, not like an IRA. But so you have to understand your trust well enough so that you fund it. And then throughout your lifetime, you must manage it. You have a new account, title it in the trust. If you become incapacitated, there's a successor trustee. They manage everything. So a trust can be a revocable living trust can be a really good planning tool. It depends on your situation. In Washington, we don't often recommend it, unlike other states like California. The recommendation definitely is a revocable living trust. And I may be dating myself, but Susie Orman, who's a financial planner, you can buy her documents online. She's not a lawyer, but she sells documents. She'll say everybody needs a revocable living trust. And some financial planners will too, because they don't understand why you might not want a revocable living trust. So why do people like them? Because they avoid probate if they are set up correctly, which frankly, oftentimes they're not. They're not managed correctly. And if you have a revocable living trust, you know that you also have a will that's it's called a pour over will. Why is it called a pour over will? It's because for those assets that aren't in the trust, they have to go through probate through this will that puts them in the trust where they should have been in the first place. So on death, not only is there a trust administration, which by the way, must be done correctly, but there's also a probate because a trust wasn't managed correctly. Often, very often, we see that with revocable living trusts because people don't understand what they're supposed to do and they're hesitant to go back to their lawyer. Their lawyer didn't explain it correctly. The lawyer, if they contacted the lawyer, they're fearful that they're going to have to pay more fees and they don't want to pay more fees. They think of revocable living trust as one and done. It is not. It is for the rest of your life, you must manage. So keep that in mind if you think that a revocable living trust is great, you don't need to do anything, and on death, it'll do it all itself. No, people need to be involved and do their jobs correctly, which they often won't do because they won't involve the lawyer, so they don't want to pay the lawyer. And so it doesn't end up as intended. So a revocable living trust is supposed to avoid probate. Sometimes it does, sometimes it doesn't. Why is it a good planning tool if it's done correctly? Let's say you have property in Arizona, for example, or California, but you're a resident of Washington. You don't want to do probate in every place where you own real estate. A revocable living trust might be a good idea. Now, is it a good idea to have a revocable living trust if you don't own property in multiple states just to avoid probate? Maybe, maybe not. What's your situation? Well, you might be saying, Lynn, I have been told probate is horrible. If you've been told that, you've been told that either by the news or some outlet or by somebody who is selling revocable living trusts. I'm sure we've all heard something called trust mills. I mean, it's really not the legal planning. that is the standard. It's just sign a revocable living trust, you're done. They might be saying probate's horrible. But in Washington state, what I will tell you is probate is not horrible if it's a good estate plan. Our rules are clear. There is no court intervention, meaning if the estate qualifies, which will be the case if it is a estate that has more assets than debts, and then the court won't be involved. The court will simply sign an order that says the executor, the personal representative, is appointed. They go do their job, hopefully with the help of an attorney who makes sure they do it correctly. Creditors are notified, assets are gathered, the estate, if there's any taxes owed, they're paid, and then the assets are distributed without the court being involved in the process. So in Washington state, probates are not to be feared just because it is a probate. They would be something to be avoided if there's no benefit, or if, well, typically probates, they'll often happen because somebody had no estate plan. So it's going under the laws of intestacy, meaning that there was just no plan in place. And as a result of that, yes, there's often problems. But with a good estate plan, probate can be a really smart thing to do. Let me give you an example. So if you're an older couple and you're concerned about long-term care costs, for example, maybe your spouse does have a condition which will require long-term care, and it's going to be expensive. I think one of the biggest fears that older folks have is that they're going to run out of money. And if they face long-term care costs of $10,000 a month, $15,000 a month, it's not going to take long for them to run out of money. So this is a real genuine concern that people have. Here's what an appropriate estate plan to secure your future might be if you are in that situation of being older and concerned about long-term care costs. I'm going to take a really simple example. Let's take Betty and Fred. Say they're in their 80s. Let's say that they have $1 million estate. What that means is we're not concerned about estate taxes. Just have $1 million estate. Okay. The house is worth 500, their investments are worth 500. In that kind of situation, we likely would recommend to this couple that they have a will, which includes a mandatory asset protection supplemental needs trust. You know, that was a lot of words. What is that? In their wills, each of them will have within it a trust to benefit the surviving spouse. So the trust doesn't take effect until the will takes effect. The will takes effect when somebody dies. When they die, there is a probate. The will must be probated. Through that probate, this new trust that was within the will is created. That trust will hold the assets of the deceased person. So Fred and Betty, let's say Fred was frail, he died first. On his death, Washington is a community property state, so I'm going to use an example of 1/2. Let's say we put $500,000 in the liquid assets, not the house, into this trust for Betty's benefit. Why would we do that? The reason we would do that is Betty is going to need long-term care, or she's concerned she will. If she's got Alzheimer's, we know likely she will need long-term care. Even if she doesn't, she knows that she sees it in her friends around her and other people that she might be needing long-term care. By putting the first spouse to die, Fred's half of the estate, the $500,000 into this trust when he dies, that will be Betty's nest egg. It is for her benefit, only for her benefit during her lifetime. It is for her. Most couples want to provide for each other. But let's say Betty needs long-term care. Let's say that when Fred died, he'd been caring for Betty at home. She has Alzheimer's, for example. She's going to need to move to a memory care facility because there's no way she can live independently in this house. She needs care. So, depending on where Betty lives, What is the facility going to look like? It's a memory care facility. From Medicaid's point of view, Medicaid will say, Betty, you are immediately eligible for Medicaid. And you might be going, what? How is that possible? I had heard that Medicaid is an impoverishment program for single people, and being a widow, she's a single person. That's true. But what I want you to understand is because this couple had the right estate plan, when Fred died, he was able to protect his share of the estate, $500,000 for Betty. That $500,000 that is in this trust, Medicaid ignores. Medicaid doesn't count it as belonging to Betty because the will had a trust with this supplemental needs trust language in it, such that the state of Washington looks at it and say, that's not Betty's money. So what does Betty own other than she doesn't own the trustee is actually the legal owner of this trust. The trustee could be the kid's adult son, adult daughter, some family member that's reliable. So what else does Betty have? She has a house. It's worth $500,000. A house is a non-countable asset for Medicaid if it's below a certain level of equity, which is above $1 million for a single person. So Betty is immediately eligible for Medicaid without any required spend down. Will she go immediately into a Medicaid paid facility? Maybe, maybe not. Depends on where she lives. If she lives in Kennewick and Tri-Cities, the answer is probably she can. If she lives in the Puget Sound area, it's probably no. She's going to have to privately pay at a facility until their private pay requirement, which could be 3 years, could be less, could be more, is met. But regardless, what's going to happen is that $500,000 that's there, even if that was the only asset, it can pay for her private pay, but nothing in that trust will ever interfere with her eligibility. When it comes to providing long-term care, we are very much advocates that you work with an aging care manager to make sure that it's proper placement. The placement is the most important thing. Then the asset preservation Medicaid plan comes next. But what we can accomplish with having the right estate plan for this older couple concerned about long-term care is we can protect half the assets with certainty. Can we protect 100% of the assets? Possibly we can. If we knew that Fred was going to pass away, we can take and put all the assets into his name via a separate property agreement. Everything is his on his death. Everything, the $1 million funds that trust for Betty and for her future. That's how you can secure your future for you and your spouse with the right kind of will, if that is your situation. Now, probate, yeah. Probate is going to be required. Let's say that probate costs $10,000. That's possible. It can be less, it could be more. I'm just letting you know that probate will cost money if an attorney does it. We've protected $500,000 to $1 million. Whereas if you avoided probate because you had a revocable living trust, you can't protect any of that money. Medicaid will count it all. You cannot use a revocable living trust in the state of Washington to create that nest egg for your spouse against Medicaid spend down. So very big differences between a revocable living trust and a will in Washington. So in this situation, you can see how a will with this trust in it and a probate makes a lot of sense.